Ambassador David Scheffer. He was the first United States war crimes ambassador. He was appointed by President Clinton. He served before as well in the Clinton administration on the National Security Council staff and as an aide to Madeleine Albright, who was representative to the United Nations at the time. Since then, Ambassador Scheffer has been a visiting professor at the Northwestern University School of Law, as well as other distinguished law schools. And he is also currently the legal analyst for CNN for the Saddam Hussein trial. In that capacity, he listens to every moment of the Saddam Hussein trial and then goes on TV to analyze it. So he is incredibly well experienced and knowledgeable about today's topic, which is Saddam Hussein's trial, political theater, or justice. And we may have an opportunity as well to use this as a springboard to talk about other international criminal tribunal issues. So let's welcome Ambassador Scheffer.
Thanks, Professor Hawkins, very much. Appreciate that, and it's a great pleasure to be here. It's my first visit to BYU. I've spent time in your airport at Salt Lake on occasion, but I've never kind of gotten out of there and seen the mountains and whatnot. It's a fantastic campus, and you should all be inspired in this setting with the beauty of it. I wanted to talk today about Saddam Hussein's trial. This is something which has had its fits and starts, as you know, throughout the last few months. There have only been a small number of actual trial days so far because there continue to be suspensions in the trial as various issues are ironed out between the judges and the defense counsel and the prosecutor, and as various holidays take place on the Muslim calendar in Iraq. That derails the trial process even more. But it will begin again on Tuesday, February 28th of next week. And for those of you who want to occasionally sort of see it on TV, unfortunately, you get a lot more of it if you have access to CNN International, which is what you would watch if you were anywhere else in the world other than the United States. And that's what I'm on all the time, talking about the trial. CNN Domestic will pick up some other commentators, but between the hours of, this is Mountain Time, right? Yeah. Between the hours of 10 and 11 in the morning, Mountain Time, on a trial date of the Saddam Hussein trial, the domestic CNN takes the international feed for that entire hour. It just brings in the international program and airs it, on the domestic channel. And that's when, if you want to see any of my commentary on that particular day, you'll probably see a little bit of it during that particular hour. In any event, the critical question that has confronted all of us with Saddam Hussein's trial, as we have seen it unfold, is whether we're watching an exercise in political theater that equates fairly closely with, as some reporters have said to me, is this chaos? Is this a circus? Is this madness? What is this that we're watching in the courtroom? And those of you who have read about it or seen a little bit of it on TV, you know what I'm talking about. There's a lot of shouting. There's a lot of belligerence on the part of the defendants. There are defense counsel walking out of the courtroom, being shoved out of the courtroom or denied re-entry by the presiding judge. There's a presiding judge who now, contrary to the first presiding judge, is shouting quite a bit. And we've been through quite a saga, and I'll talk about that a little bit as we go through these slides. So it has not been a smooth ride whatsoever in the courtroom. And it leads a lot of cynics of international justice to say, see, I told you so, this really doesn't work, you can't really do this with political leaders, you can't really put them on trial like this. And for those of us who have been in this business for a long time, and for me it's since the early 1990s, What we see unfolding in the Iraqi High Criminal Court in Baghdad is not that surprising. It is something that has to be corrected over time, but it's rather normal when you have individuals like Saddam Hussein in the courtroom to see a fair amount of hyperbolic rhetoric and just a lot of disrespectful conduct in the beginning, until things can start to calm down, until the defendant really realizes that he's there, he's going to be tried, he can't stop this now, he better get his act together. And that is what always happens in the trial. But you do go through these early stages of chaos, and it happened with the Yugoslav Tribunal, it happened with the Rwanda Tribunal, with the Sierra Leone Special Court, and I suspect we'll continue to see it for a while with the Saddam Hussein trial. But anyway, it's a good story, so let's start it. Left. Yes, okay. Political theater. Why would we consider this to be an act of political theater instead of pure criminal justice occurring in Baghdad today? Well, it is political theater in part because of the types of points that Saddam Hussein and his colleagues, he has 7 additional co-defendants in this particular trial, which we'll talk about in a second, but they certainly have certain objectives to try to achieve in these early days of the trial. One of them is, of course, to try to discredit the court, try to make the world believe that this court is not a credible court to be trying them, that there are deficiencies there, that it's an illegitimate court, that this is not real justice. This is, as the second point makes clear, this is the appearance of victor's justice. The Americans set up this court. This is a railroaded process. That's the point that they're trying to obviously instill in these early days. They also have the objective of trying to prolong the trial, because obviously if the death penalty is available, and it is in this court, the sooner the trial is over and a conviction is rendered, then the sooner the possibility of the death penalty actually being imposed. So if you want to stay alive, prolong the trial. And the longer you prolong the trial, the greater chance you may have to uncover certain weaknesses in the prosecution's case that are ripe for appeal. And, of course, then when you take it to the appeals level, you can prolong it even longer. So what do they have to lose, frankly? And then create a circus atmosphere so that everyone out there in the rest of the world views this to be a totally farcical endeavor, and to try to shame the judges and the prosecutors and those who support them so that their image internationally is tarnished. So you can imagine that from the defendant's point of view, there's a lot of work to be done in that courtroom to try to disrupt it and derail the entire process. But again, I say, of all of these factors here, none of them surprise me. I mean, if you're a judge sitting on the bench in this court, you've got to anticipate that this is what their strategy is, and then respond to that strategy. The flip side of it is trying to achieve justice. Why have this trial to begin with? And one way to start going through it is, first of all, one can make the argument that this court, in fact, has achieved legitimacy in terms of the way in which it not only was created but was reaffirmed by the Iraqi National Assembly last August. So there have been steps taken since the court was created in December of 2004, if I'm remembering my dates correctly here. Yes, 2004, when the court was created. Many steps have been taken to try to strengthen the legitimacy of the court. And therefore, the argument that it's an illegitimate court can be rebutted. Second, the court has taken on a relatively professional staff. The court is supported almost entirely with the money of the United States government. $128 million have been used now to finance the operation of this court. Almost every dollar of that is U.S. money. The United States was not able to achieve any support of any significance whatsoever from any other country for the operation of this trial. And of course, that's a point that the defendants are making big time, that this is victor's justice. No one else believes in this court. No one else is helping to finance it, et cetera, et cetera. But the point is, with a sufficient amount of funding, they're able to pay the judges decent salaries, the prosecutors. They're able to use those funds to uncover evidence, to dig up the mass graves, to pour through the documents, to have the interpreters that are necessary and the translators. All of this costs a lot of money. And unless you have that financial base, you can't really make it with a crime, with a trial for these types of crimes. Then international standards of due process. The court has been created with the idea in mind that it would try to follow, to the extent possible, international standards of due process, and we call that sort of internationalizing this court. This is a domestic Iraqi court. It's not an international court. It's an Iraqi court, but it is of a special character, operating under a special charter with special rules, and a lot of them incorporate international criminal procedure into the operation of the court. So that enhances the view of justice being actually rendered here. And as the trial goes on, there are Herculean efforts to demonstrate fairness towards the defendants, to allow them to rant and rave for a while, give them the ability to vent in the courtroom, don't shut them up too quickly. And remember, this is for all of those who watch Law and Order and all the other law shows, Boston Legal, etc., you know that a defendant has a very limited role in his own trial. He doesn't speak. He doesn't speak unless he's put up on the witness stand, and then he's cross-examined. And the defendant is put up on the witness stand. And the defendant himself has absolutely no right to stand up and ask questions of anyone. It's defense counsel that does that at the appropriate time. It's very different in the Iraqi court. The defendant has the right to stand up and speak on his own behalf. Then his attorney can speak. The defendant can ask questions of all of the witnesses directly through the judge. So can the defense counsel. So you have this sort of double-barreled approach, and that's why you see so much of Saddam Hussein and his half-brother al-Tikriti on the screen so much, is they actually have the right to stand up and vocalize in the courtroom. But the problem is there are rules that can be broken when they do so. In other words, they can't do so in a way that violates the actual procedure of vocalizing, of asking questions, and nor can they use the opportunity to abuse and disrupt the courtroom. So the judge has the discretion to discipline them, but don't be mistaken. They have the right at various times each day to stand up and say something. And they use that right, but then they abuse it. So we have this tension now between the bench and the defendants. It's a very different process from what you're used to on watching on TV. And then finally, there are serious issues. Despite what may be the view of justice for this court, there are very, very serious issues that have to still be resolved before one could say that this trial is on track as a fair trial. Something that I found bizarre from almost the early days of the trial, and you try to get used to this as you're watching, obviously, a foreign trial in a foreign court, is that it is very normal in our courts in this country and in the international criminal tribunals in The Hague and in Arusha and where we have international courts set up to try atrocity lords. It's very natural for the defense counsel of these people to stand up at the very beginning of the trial and claim that the court is illegitimate and bring all sorts of other complaints about lack of jurisdiction for the court over their clients, etc. All of these are defense motions, and it's a normal procedure. Defense counsel wouldn't be doing his job if he didn't create these motions. So you get this profusion of motions at the beginning of the trial that force the judges, really, to say, well, wait a minute, we have to establish our legitimacy, our jurisdiction, and we have to deal with other procedural issues that defense counsel has just raised with us before we can really get on with this trial. And that is exactly what our courts do. They deal with those issues of legitimacy and procedure at the very beginning, and it means that taking evidence in the trial doesn't begin for quite some time, because they have to go through that, and then they deliver their judgments with respect to these initial motions, and then you start the trial. Then you bring your witnesses in and all that stuff. They didn't do that in Baghdad. The defense counsel delivered their motions, claiming the court was illegitimate and all this stuff. And the presiding judge just said, okay, thank you very much. We'll take a look at that when we can. First witness, And so, there's kind of a pretty legitimate gripe that defense counsel have right now. He's saying, wait a minute, what's going on here? All this evidence is being produced, and the fundamental questions about the legitimacy of this court are just sort of floating out there somewhere. So that's a problem. And I trust the judges will solve it soon. I hope so. I want to just show you the magnitude of the criminal record of the Saddam Hussein regime before we talk about the very case that is on trial right now. The criminal record is extensive, and it stretches over essentially a 20 to 25-year period. And it includes atrocity crimes, namely genocide, crimes against humanity, or war crimes, committed during all of these various situations during the Saddam Hussein regime period, which stretched from the late 1970s until he was thrown out of office after Operation Iraqi Freedom in March of 2003. And you can see I'm not going to explain all this to you, but there's a lot there to work with. And during the Clinton administration, when I was on deck, we actually had a very, very serious and well-financed program of collecting evidence on all of these crimes. And all of that evidence, was collected during the 1990s and, of course, made available to the Iraqi High Criminal Court once a court was established to do something with the evidence. Okay. Anticipated prosecution cases. They're currently involved with Dujail. Oh, this works. Okay, Dujail, 1982. That's the case that's in front of them right now. But it's a strange beast, because as horrific as the Dujail massacre or crime was in 1982, it pales in comparison to the Anfal campaign, to Halabja, to Kuwait, to the Shia uprising, to the Kurdish uprising, et cetera, et cetera. 146 or so men and boys were killed at Dujail in 1982 after a alleged failed assassination attempt in that town against Saddam Hussein. So this was retribution, kill 146 people. And then 500 residents of Dujail were taken off for torture and multi-year imprisonment until sometime in the late 1980s. They were released back to their town in Dujail after being tortured in 2 different locations, including Abu Ghraib, and then they were dumped into a desert prison in southern Iraq to live for several years in that desert before they were shipped back to Dujail. That was 500 people. So that's the crime. And it's interesting, as the evidence started to be produced in the trial consistently, I say consistently, for those who spoke to the issue among the witnesses, they said, I heard those shots fired, and these are the shots that presumably were aimed at Saddam Hussein to kill him. He was visiting the town at that time. And they said, all of us at the time took that to be our traditional greeting. In other words, in so much of the Islamic world, you take your gun and you're fired into the air to say, hello, hi, how are you? We're great, glad you're here. And they said, those were celebratory shots. No one was trying to literally kill Saddam Hussein, but of course it was read as, and it could have been an attempted assassination. Who knows until the evidence is really in. But the point is, there was a quick retribution. Now, that to us would be a horrific situation if it occurred here in the United States. Somehow our government goes out and kills 146 people because of some attempt on some official on some street in America. That wouldn't happen. But it does pale in comparison to all of these other crimes. And I'll talk about that in just a second in terms of the wisdom of pursuing such a relatively minor crime against Saddam Hussein. Alternative trial strategies. During the 1990s, it's important to understand the context of why are we where we are now in Baghdad with the Iraqi High Criminal Court. The alternative trial strategies experimented during the 1990s, during the Clinton administration in particular, was in 1994 we commenced a process up in New York at the UN to try to get agreement to create a UN commission of experts to look at the crimes of the Saddam Hussein regime in order to establish that it is of a criminal character, and then the normal procedure is for that commission then to make recommendations, and normally the recommendation would be build a court to bring this guy to justice, some kind of international criminal court. But your first step is a commission of experts. So we tried for several years to get that authority out of the Security Council, and we failed in part because of all of the politics involved with Iraq during the 1990s and the commercial relationships that certain permanent members of the United Nations Security Council anticipated with the Saddam Hussein regime once sanctions were lifted, and why go into some sort of accountability exercise if you can actually make a lot of money out of this. So we weren't able to get the support of certain key countries in the Security Council. We then just shot the wad and went up there and blatantly and publicly said, we want an ad hoc criminal tribunal. Why are you opposed? And we made some progress on that. We got some allies, but again, we didn't get enough votes in the Security Council to create such a criminal tribunal that would at least indict Saddam Hussein and his colleagues. And then if the day ever came when we could gain custody of them, then we'd have it all set up for the trial. And then finally, when we failed at that, we started to explore, flew all over the world to talk to governments about whether a foreign national court could exercise universal jurisdiction or some kind of jurisdiction to at least indict the leadership of Iraq. And, of course, Kuwait was the prime candidate here because Kuwait had been victimized by Iraq. But that failed, too. Okay. There was one lost opportunity in late 2002 when we had the most leverage at the UN to actually set up that long sought-after international ad hoc criminal tribunal that could have started the process, taken all the evidence, indicted the leadership, and then when they were captured, you'd have a whole process underway, international, impartial, great security, financed by countries around the world, not just the United States. All that stuff would have been accomplished, but that moment was not seized. And therefore, we don't have these advantages working for us now that I list there. Okay. The final point here that I do want to emphasize is focus on largest atrocities and strategize more holistic approach to the trials. The reason I say that is that the current strategy of the Saddam Hussein trial is to take 12 separate atrocities, as I listed before, remember, Dujail being the first one, and just run them through one at a time, sequentially. Now, that's one way of running a criminal trial, a criminal prosecution, when you have defendants who have committed so many crimes. But there's also an alternative, which I think makes, and this is very debatable, but in my view makes more sense when you're dealing with those who lead countries, who create such massive crimes in such a planned, orchestrated, systemic manner. And that is to take your time, build a massive case against them that has multiple crimes involved, and then pursue it holistically in the trial. That is not the way it was decided by the existing Iraqi criminal court, High Criminal Court, but it is, I think, it might have been a more logical approach for an international criminal court if one had been established. It's similar to what we see now in the Milosevic trial. That is a holistic trial. All of his crimes are together in that prosecution. Everyone's so upset that we're now in the 5th year of the Milosevic trial, and my caution is, hey guys, we're dealing with atrocity crimes. This is not just a single murder. This is hundreds of thousands of people. Enormous destruction, ethnic cleansing, displacement of thousands and thousands. And you bet it's going to take some time to investigate and prosecute someone responsible for that, and just be patient. That's my response. But anyway. Okay. Iraqi High Criminal Court jurisdiction. I'm not going to spend any time on this since this is not a law school class. But I will simply say that for us who are lawyers, this is the fascinating stuff, because we're able to identify, well, how does this court really function? Where does it get its legitimacy, its jurisdiction to do its business? And, of course, it's in its underlying constitutional document, which we call its statute. And you can see here that this court can only go after Iraqi nationals or residents of Iraq. No Americans, no Europeans, no Russians, no one like that can be subject to prosecution. Temporal jurisdiction means that any crime committed between July 17th, 1968 and May 1st, 2001, anything before or after, can't prosecute it. Territorial jurisdiction, crime had to occur in Iraq, or it says or elsewhere, which is a very interesting, we don't know what that means. Subject matter jurisdiction, this means that the crimes of genocide, crimes against humanity, war crimes, and various crimes under certain Iraqi laws can be prosecuted in this court. One being attempt to manipulate the judiciary, wastage or squander of national resources. That's when they drain the southern marshes. The aggression against an Arab country, Kuwait and Iran. And if you default on any of these, you can go to various parts of Iraqi penal law. But we're not going to worry about that. Okay, structured judges, don't bother with this, just to let you know that there are 5 judges, a lot of Kurdish judges you see there. Appeals chamber, one option for a non-Iraqi judge has not been exercised. They're all Iraqi judges. And here we come to Dujail. And you have 8 defendants, and you see that they're clustered in leadership defendants, and then you have these former Ba'ath Party officials who are very sad-looking characters in the courtroom. They were the sort of the local officials, who really made the atrocities run on time. And here they are, and they don't have much to say in the courtroom. They don't jump up at all. They let their leaders do it. And then defense counsel, you see one is from Jordan, one is from Qatar, and then you have good old Ramsey Clark from the United States of America. I have come across him many times in my life. He represents those who commit genocide, and he's an interesting character now, and has so displayed himself in the courtroom. Defense counsel, several have been killed, seriously wounded, fled the country. That causes a huge problem, obviously, in the fairness of the trial, having competent defense counsel chosen by the defendants. If they're getting killed, that doesn't work. Okay. Now, what are the defense arguments in the Dujail trial? We've already mentioned this very briefly. Legitimacy of the court is obviously subject to scrutiny. That this court was set up during a military occupation, has the United States written all over it. Oh, I'm sorry. Stay close to this. Yeah, that it has military occupation all over it, and therefore it's an occupier's court. And under occupation law, you should just understand they do have a point. Under occupation law, if you're a military occupier of territory, you're not supposed to create any non-military court on that territory. You can create a military court to deal with, little war crimes that occur during your occupation and stuff, but you're not supposed to create a non-military court. And the rationale for that is that occupation law is actually supposed to be tough enough to be a disincentive to occupy foreign territory. If you have to occupy foreign territory, be fast and quick about it. Don't sit there and change the country if you're an occupier, because we don't want to write a law that actually encourages you to invade another country, occupy it, and change it. That's not how the law works. So they would argue this was, this is not a military court. This is a civilian court, and somehow it was created during military occupation. What is that all about? And that's what the judges have to rule on. They have to rule on that and move on, but they have refused to rule on that. So you can imagine defense counsel saying, what in the world is going on here? Illegal intervention and occupation, of course, that's the whole issue of Operation Iraqi Freedom, which we don't have to get into. Independence of the Iraqi judges. The presiding judge right now is a Shia who, I'm not Shia, that was the former one, is a Kurd who grew up in the town of Halabja. Does that ring any bells? Halabja was one of those major atrocities. 5,000 people gassed in 1988 by Saddam Hussein regime. This guy's a resident of that town. And furthermore, he was tried in absentia, or I don't know if it was in absentia or not. I think it was, in the 1970s by the Saddam Hussein regime, and for some sort of political activity that was contrary to the regime. So defense counsel are crying foul. This guy is tainted. Conflict of interest. You've got to get him off the bench. He's prejudiced. Again, that's something the judges have to sort of say, all right, we'll rule on that. We'll give you a reason why he's either going to stay there or not stay there. But they can't just be silent on those arguments. Anyway. Okay. Further, and I find this one of the most interesting ones from a political science perspective. Regime's reaction to the Dujail assassination was in fact a law enforcement action. Our leader, Saddam Hussein, there was an attempt to kill him in 1982. Now, we have to, this is a law enforcement issue. We have to go into that town, find out who was part of the conspiracy to kill Saddam Hussein. We have to question them. So all of this was legitimate to do all of that. And then defense counsel have raised the fact that, well, wait a minute. In 1993, President Clinton sent various cruise missiles into downtown Baghdad in retaliation for a plot by Saddam Hussein to kill President George Bush I that we had discovered. And so, some civilians died when those cruise missiles landed in Baghdad, so that's law enforcement, isn't it? And so they raised that argument, what is this, double standards? And then they also threw in the fact that, this is just, defense counsel being defense counsel. The current president of the United States, when he was Texas governor, signed 152 death warrants. He killed more people as the governor of Texas than Saddam Hussein is alleged to have killed for an attempted assassination in Dujail. So anyway, another argument they raise is security for defense counsel, that they should have a lot of security, that they shouldn't be assassinated when they walk out of the courtroom. They also complain about the youth of so many of the witnesses in the trial. A lot of these witnesses were 10, 12, 13 years old at the time of the Dujail massacre, and now they're much older. And the defense counsel are arguing, how can we possibly trust the memory of a child? So it's a very interesting issue because we deal with that a lot in U.S. courts all the time, of course. And then, of course, they play the sovereignty card saying that this is an American intervention, judicial intervention in Iraq that no one should pay any attention to. And then finally, they claim that they have actually been tortured and abused by their American guards during their incarceration prior to this trial and during the trial. And so they're trying to incriminate the U.S., which is an easy pot shot at the U.S. given what has come out on Abu Ghraib, and so they're taking advantage of that and throwing that in our faces. Okay. These are not worth dealing with right now. Although the head of state immunity one, Saddam Hussein still thinks he's the head of Iraq, and he still thinks the judge should pay deference to him as the head of Iraq, and he's also saying that I should still enjoy the immunity of being the head of Iraq. So what am I doing here? Okay. And then his political agenda is becoming increasingly apparent, to focus global attention on the legality of the court, legitimacy of the American intervention, et cetera, delay the final verdict, prolong and sensationalize the trial, and then it's also a media hotline to the alienated Sunnis. He has a lot of supporters still in Iraq. If he can get up in the trial and communicate with them, the last time he walked into the trial, the first thing he said, one of the first things he said when he walked in, he shouted, "Long live the insurgency." Is anyone here listening to me out there, in Iraq? Long live the insurgency. Can you imagine, for those who support him, who are part of the insurgency, they just got a direct message from their leader to keep at it. So, he's using that platform. And I mentioned just after he did that on CNN, I said, I think the courtroom can tolerate a lot of his outbursts on a lot of subjects. But when it comes to actually imperiling the national security of Iraq by trying to stoke up the insurgency so blatantly, that's when the judge really has to make some serious decisions about his ability to have the privilege of speaking up in that manner. Okay. More insidious political agenda would be ultimately to compel an American withdrawal, seek a strategic victory, undercut their argument for national trials rather than international trials. Let Ramsey be Ramsey. Ramsey Clark is a big proponent against the Operation Iraqi Freedom. He thinks the whole thing was illegal, and he's using this forum to promote that point of view. So from defense counsel's point of view is great. Let Ramsey be Ramsey. Let him just go at it. Discredit and humiliate the witnesses, the prosecutors, the judges, and this is a really insidious tactic. You got to remember that at the end of the day, the witness testimony is extremely graphic, it's horrific, it's damning, but they're succeeding in drowning it out with all of these antics in the courtroom. So there's a strategy here that does essentially work on their part. They can drown out the evidence of these crimes, at least for public consumption, by focusing all of our attention on what they are doing in the dock as opposed to what the witnesses are saying with respect to the crimes that actually occurred. And now, most recently, in his last appearance, he said he's on a hunger strike. The judge, Bandar, also the indicted judge of the Iraqi regime, Bandar, also said that he was on hunger strike. Al-Takridi, I think, said that the half-brother, who's the head of intelligence, said he was on hunger strike. So now we have this dilemma. What do they do with defendants who are on hunger strike? And you've probably read about what we're doing to them down in Guantanamo on hunger strike, and that's very controversial in terms of human rights of the defendants and how we're force-feeding them. Now this whole question will come up perhaps with Saddam Hussein, although my guess is that the hunger strike will not be sustained very long. I think he probably likes to get a good meal. But anyway, it is out there. And I'll wrap this up very shortly. The defense counsel clearly have their own strategy as well in unison with the defendants. They have a walkout strategy, which they've employed several times now. Ramsey Clark has been at the head of this, which is, look, if we don't get our way, we're just going to walk out of here. And then you're deprived of having counsel in the courtroom, which you should have for due process and fairness and all that stuff. Well, if we're not there, that's not going to happen. And the judge has responded by, all right, you walk out, then I'll assign counsel. I'll bring assigned counsel into the courtroom. The problem is when the assigned counsel walk into the courtroom, Saddam Hussein and all of his colleagues in the dark scream bloody murder. They don't want those lawyers. They're not lawyers of our choice. I don't want to talk to those lawyers. Who are those guys? And so you have this running battle of, well, is the defendant being properly represented if there's no communication between defense counsel and defendant? So they have a lot of cards that they're playing right now. They want to seek removal, the lawyers do, of the presiding judge because of these conflicts of interest issue. The presiding judge has said, look, defense counsel, who are the chosen defense counsel of the defendants, you can walk back into the courtroom if you do two things. One, you apologize to me personally for your terrible behavior as defense counsel. And secondly, I want you wearing those green sash robes that you're supposed to wear as defense counsel in this courtroom. So don't insult this courtroom by not walking in with your green sash robe. So I like to be a little more pragmatic, and I would sort of, if I were on the bench, I'd work something out with defense counsel a little more reasonably, because it's very important. The judges have dragged the defendants back into the courtroom against their will. They walked out. They've been dragged back in against their will, which is fine. I have no problem with that. I think the judge has every right to do that. But if he's going to do that, he needs to consider bringing the chosen defense counsel back into the courtroom, even though they've had this little, argument among themselves, a little, tension. I think the interests of justice are far more important to get the chosen defense counsel back in the courtroom. Forget about getting an apology from them. I mean, after all, we all have to have thick skins in this business. All right, now I'll probably finish with this because I want to get to questions. Prosecution's risks. I've mentioned this before, that they have taken a great risk. They've taken what is essentially an easy case, the Dujail assassination attempt. And it's in comparison to doing a mega case like the Anfal campaign of the late 1980s against the Kurdish population in northern Iraq, which just killed tens and tens of thousands of, hundreds of thousands of Kurds, or the invasion and occupation of Kuwait. They've taken what is a relatively small crime. Now, that eases the prosecution's burden in the courtroom, and there's merit to that for the prosecution. But it's going to be very, very difficult to establish the direct responsibility of the leadership for the crimes in Dujail. We call that command responsibility. And they may be able to succeed in doing so, but they've taken a risk in that even if they are successful in this trial, there is a requirement under Iraqi law that the sentence be carried out within 30 days. So if he gets the death penalty, he's supposed to be executed within 30 days of the delivery of the death penalty, unless somehow they figure out to keep him alive so that he can stand trial for the 11 other crimes. And they have the power to make that decision, but it's going to be just another obstacle that they're going to have to confront to keep him alive so that he can stand trial for all of these other crimes. The other big issue that you see play out on the television screen so much is the disadvantage of having such a joint trial. There are 8 defendants. All of them have their kind of own agendas. They're all jumping up at different times. They're shouting about their health. They're complaining about the lack of a lawyer for one as opposed to another. And what that does in a trial is that whoever is the weakest link or the most disruptive link among the defendants pulls everything else down, you see. So by bringing all of these defendants together in a joint trial, they have created the opportunity to derail the trial constantly with just one defendant's problems. And that is a problem that they're clearly having to deal with. I wish I could tell you some more about the witness testimony, which is a very, very compelling testimony in the courtroom. But I think that what I would suggest is this consistent experiences way abuse and torture. It is astonishing how, as each crime witnesses, first they put all the crime witnesses up who actually suffered the crimes. Then they put the regime witnesses up, those who actually are able to establish a link between those in the dock and the crimes. But the crime witnesses have told a fairly consistent story of how they're taken first to the Iraqi intelligence headquarters in Baghdad. They're tortured mercilessly there. Then they're taken to Abu Ghraib, tortured some more there. And then ultimately they're transferred to that prison in southern Iraq, which is a desert prison for which they can't possibly escape. It's just they kill themselves in the desert if they did. And so all of this testimony has been very consistent. And defense counsel, of course, shot back saying, Your Honor, we believe that all of these witnesses have been stage managed because everything is so consistent. How can that be from one witness to the next, that they were all cold, that they were all beaten, that they were all hungry? I mean, what's going on here? And, of course, that's defense counsel doing what they do. And some of these other things, a lot of electric shock. Everyone was, of course, always stripped and then beaten. Women were hanged up by their feet and nude and beaten. All sorts of pretty awful stuff. And then I'll skip that for now. And I just wanted to show you that even within the Iraqi Criminal Procedure Code, you can see where it's possible for the court to discipline the process with the defendants, okay? by prohibiting any individual from just walking out of the courtroom and punishing them if they do, that defendant may not be removed from courtroom during consideration of case unless he violates the rules of the court, in which case procedures continue as if he were present, must keep him informed. And I've suggested that, as have others, that if these defendants continue to be disruptive in the courtroom, then just keep them in the cells, give them a video feed of the proceedings, and I've even suggested make sure that one of their chosen lawyers sits in the cell with them to explain what's going on, to communicate any requests they may have, to assign counsel in the courtroom so that due process is constantly dealt with. Enforcement, I'm not going to deal with that for right now. Next steps. These are the things that I think should be done, but doesn't mean they will. Trial resumes on February 28th. I think those judges should issue their opinions on all these issues that are outstanding. Defense counsel should be invited back in. If the defendants abuse the process, video feed them. Consider a new strategy for subsequent trial and change of venue, and appoint at least one non-Iraqi judge, at least appoint the one non-Iraqi judge that they're entitled to under the statute to the bench. I think they really do need an experienced international criminal law judge, and we've got a lot of them now, to sit on that bench with the Iraqi judges and help guide the process. So I know that's been kind of intense run through, but I wanted to use this opportunity to really sort of feed you a lot of detail about this process, because you're going to be watching this now for a long time to come, this trial and subsequent trials unfold in Iraq, I think, unless they ultimately decide to move it outside of Iraq for security reasons and other reasons. Anyway, that's where we are, and I am open to any and all questions, not only about this court, but feel free to ask me questions if you wish about any concerns you have about the International Criminal Court, about the Yugoslav Tribunal and the Milosevic trial, about the Rwanda Tribunal, all those kinds of things. Yes, sir.
You talked about Ramsey Clark being involved in the defense.
Yeah.
What is his argument for why the legality of the operation, the American operation, is within the scope of the trial?
Oh,
is
because,
it within the scope of the trial?
Yeah, he draws the argument out that, look, if the premise of this court is that it was set up by an occupying authority, the Coalition Provisional Authority working with their hand-picked Iraqi governing council actually set up this court. This court was set up during an illegal military occupation. Now, why do I say it's an illegal military occupation? Because guess what happened in the spring of 2003? There was an illegal intervention into Iraq. So if the original intervention into Iraq was illegal, the occupation must be illegal, and subsequently the creation of any court under such a massive act of illegality must itself be illegal. So that's kind of the line of his argument. But it allows him also to use the opportunity to press what he has been pressing for some time now, which is he leads sort of he helps lead sort of an advocacy campaign in the United States about the illegality of the war, if we put it that way. And so this gives him another platform to be out there doing that and to use it for that purpose. So he sees great advantage to being part of the legal team. Now, he is permitted under the rules to be part of the legal team. You can have a non-Iraqi lawyer on the team as long as you have an Iraqi lawyer on the team. You can have a non-Iraqi lawyer on the team. And so he was sworn into the court for this trial in the early days, and he's a legitimate counsel now in the courtroom for Saddam Hussein. Yes. And then I'll come to you.
Given that the United States also does not abide by all international rules with regards to trials and with regards to criminals, for example, executions, that kind of thing, in certain cases, and just given a lot of things that have surrounded the Iraqi operation, do they have a point? Do they have a point that some of the behavior of the United States government has cast doubt on the credibility?
Yeah. Well, I think that there's no question that they have a lot of material to work with, the defense counsel, on the issue of America's role in this whole process, and it gives them a lot to work with. And I think the most damaging argument that they have a basis for making against the United States is how we have dealt with detainees in Iraq, because their clients are detainees as well. And if you're not providing adequate justice for the thousands of detainees that you bring in as an occupying force, but then you set up a court to so-called bring justice to this government official who has been captured through the intervention and occupation, then there's a double standard there that they're going to try to take advantage of. I would just say that if we had been more sensitive and cognizant to the protection of the rights of detainees during a military occupation, we'd probably be in a much better situation right now in terms of how those defense counsel are making or using that situation to bolster their arguments. It doesn't mean that it makes the argument. It's just it's the texture around the argument that advances it in their minds, and I think in the minds of probably Iraqis as well, and probably much of the Arab world, to say, how can we pay respect to an American-financed court of this character when, in fact, America has a lot of problems to sort out in terms of how it's administering justice with respect to thousands of Iraqis and Afghans and others who have been captured during the War on Terror. Back here.
How much connection do you see between finishing the trial for Saddam and being the insurgency?
Oh, that's a great question, because you just asked a CNN reporter's question.
Would you repeat the question because
Yeah.
we're taping it?
Oh, I see. Okay. I was going to say the reporter. The question was, is there a connection between trying to end the trial of Saddam Hussein and having a significant impact on the insurgency? I mean, is there a connection between the two? And I think there are a lot of people who do view a very strong connection between trying to accelerate the end of this trial, get it over with, get the conviction out there if there is going to be a conviction, so that it demoralizes the insurgency. It shows them that justice against some of their exalted leaders of the past has now been rendered. And in fact, there are a lot in Iraq who are calling for that 30-day period for the death penalty to in fact occur, and then the death penalty imposed. In other words, none of the suspension of the death penalty while a zillion other trials take place. Because they do see it, and I think the Shia-led government right now would very much prefer to see this trial end quickly with a favorable verdict as an instrument of leverage and an instrument of power against the insurgency. So I think there's a real connection there, yeah. But that doesn't mean it's going to happen. That doesn't mean the trial's going to end quickly. It's just that there's that argument that why can't we accelerate this in order to have a power punch at the insurgency? You could just as easily make the other argument, of course, that if you end it quickly, and particularly if it's done in a way that violates standards of due process and fairness, then you're just going to give more fuel to the insurgency. You're going to inspire them to be even more violent. Yes, sir.
We have some comment coming from Iran or Russia, outside sources like that. What are they saying about the process?
About the trial? I don't know of any particular comment from Russia. Yeah, it's a good question. I don't know of anything out of Russia about this trial. Out of Iran, there's no let's put it this way. What I've seen out of Iran is quite similar to what we see coming out of the southern part of Iraq and the Shia population, which is a true interest in being as tough as possible in the courtroom with the defendants, and having a very tough judge. A lot of the criticism that you saw after the first phase of the trial, when you had the Kurdish judge Muhammad sitting there, was that he was too lax with the defendants. He allowed them to do whatever they wanted. And you did see some stuff out of Iran as well as southern Iraq that said, let's change the presiding judge. It would be interesting historically to look back and try to determine whether at any point in time Iran pressured Baghdad diplomatically. I don't know. I mean, who knows? To make some changes in the trial so that it is a more disciplined, tougher exercise of justice than was the case in the early days of the trial. The new judge, Ahmed Rahmed, is Kurdish and is very, very tough in the courtroom. Frankly, to a fault, he's too tough in the courtroom. So now we're getting problems with him being too tough and sort of overlooking certain fundamental rights of the defendants. But I'm just trying to think if there's a specific message out of Iran, and it doesn't come to mind right now. But they do align their viewpoints with some of the southern Shia viewpoints, which have been very strong on this point, that they needed to toughen up the trial. Remember also that Iran came forward, some time ago, about a year or so ago, and made the point very strongly with the American authorities and the Iraqi authorities in Baghdad that they did not want this process to proceed without a proper trial with regard to the crimes committed against Iran in the Iran-Iraq War of the 1980s. And they were very strong on that point. They said this would be an outrage if this process goes forward without the crimes inflicted against Iran also being considered. Someone else out there? Oh, Darren, yeah. Sorry.
Missed me down front.
Yeah.
One of the things that I think is most valuable about these kinds of trials, for example, Nuremberg, is the historical truth-telling ability of the trial, sort of getting truth about what happened on the record. And I'm a big fan of truth commissions as a result in many of these countries that sort of systematically look and detail everything. I worry, based on what you've said, about how much truth we're going to get out of this trial. And I'm wondering if you worry, too, and are there alternative strategies out there? Are we thinking about truth commissions and so forth?
There is a truth commission being considered now, and in fact, some colleagues of mine are starting to work on that prospect in Iraq with some funding, working with the Iraqi government as to how to build a truth commission in Iraq that would begin to collect the kind of information that we saw in South Africa and elsewhere, where you have to take these long years of atrocities and try to record them in a way for history and posterity, so that these crimes are not forgotten, whether or not anyone is ever brought to justice. So that is just beginning now in Iraq. But you're also, it is true, there is a record being built in this trial, as there has been in so many of the trials of the other criminal tribunals, Yugoslavia, Rwanda, etc. That is very, very important for history. But, of course, it's in a legal context, and so, therefore, you're dependent upon who your witnesses are, how articulate they are, and it's not the way a historian would approach the exercise in terms of ensuring there's a totality of information and understanding that is drawn upon. The trial uses only the information it needs in order to, or a prosecutor only puts the evidence forward that he needs in order to try to seek a conviction, a guilty verdict against the defendant. So it doesn't mean you get a full record.
In trials in the United States, even we often see the problem of witnesses refusing to testify or other behavior in the courtroom altered because of fear for physical safety. Mafia trials, that kind of thing. And obviously in this case, defense counsel and also the judges have received threats. How does the court keep the witnesses and the attorneys and the judge impartial and acting appropriately and acting in the courtroom when there's this threat of death or injury to them or their families?
Now, are you speaking of both the United States and Iraq under that scenario, or just Iraq?
I'm thinking specifically about in Iraq, in
Yeah.
the current trial.
Yeah, in the current trial. Well, one tactic that has been employed is to ensure that, to the extent possible, all of the personnel of the court remain, for whatever length of time is deemed necessary in the context of their participation in the trial, that they remain resident in the green zone, where there at least is enough protection for them so that they're not totally exposed to retribution and violence outside of the green zone in Baghdad, because the courtroom is in the green zone. So that's sort of the immediate issue of security, is to try to keep them there. But you're right that it does taint the process considerably, the security issue, because it means that, particularly on the part of the defense counsel, there's an enormous amount of risk and turnover of defense counsel, because each of them becomes subject to some threat at some point in time, and they have to make a judgment with their family whether or not they will remain in the process. We've already lost defense counsel on this basis. We've also lost a judge to violence. So you ask, how does that taint them? I can only imagine that it has some impact on them, but I honestly can't say that it prejudices them in any particular way. With defense counsel, it certainly gives them the inspiration, if I can put it that way, to press very hard in the trial for proper security and not to further participate in the trial until they get that security. So that's a very substantial impact on the operations of the trial. I don't know if it's a prejudicial impact, but it's clearly an impact.
And witnesses makes it really
And witnesses, very difficult, and that's why so many of the witnesses I've never seen. They're behind a curtain in the courtroom, so they're shielded from any view of the public. And defense counsel can see them, the judge can see them, and I'm not aware of any defendants having actually seen them yet. They're behind the curtain. But the defense counsel can see them.
Is the security of the witness like in the ICTY where they're behind the screens, but even I don't think the defense attorneys are allowed to see them. Their voices are changed, and a lot of times they go into closed session where they're not filming anymore, they're not broadcasting what's going on. Do they have that similar sort of setup?
Yes, they go into closed session, but they're certainly not broadcasting. But we haven't had enough of that yet. I mean, the ones that I have, I think I've seen one or two instances where a witness, the proceedings were shut down for public consumption because of the security of the witness. But normally they're just behind the screen and we do hear their voice. It hasn't gotten to the level of variety or variation as we now see in the Yugoslav Tribunal. We just haven't gotten there yet.
One more question.
How final is the decision of the court? Is there an appeals process afterwards, and how does that affect the legitimacy of the court and their eventual decision?
Yeah, there is an appeals chamber. It's called the Cassation Commission of 9 judges, and we haven't had the experience yet of an appeal in the Iraqi High Criminal Court, so it's hard to say how it will actually work. But yes, there is an appeal, and it can be based on mistake of law, error in fact, or additional facts that come to light that are significant enough to require a review, of the case. But it is certainly there. They have the right of appeal. You have to assume that every single one of them will exercise their right of appeal. And it's also why this whole trial process gets so complicated, because, the judges and there are 5 of them sitting up there, they think just as do judges elsewhere in the world, including in the United States, are the decisions we're going to make on a daily basis here, particularly in terms of procedure, particularly in terms of whether or not the defendant would remain in the courtroom or not. Has he reached a point where he's being so disruptive he should be taken out of the courtroom, all that stuff. All of that is potentially subject to challenge on appeal. And so it does add a sort of a cautionary note in the trial chamber, because they obviously have to keep in mind the possibility of appeal, which will almost certainly happen.
How does that affect the 30 days sentence?
Oh, it does affect it. You can, the 30-day clock tolls only after the final judgment, which would be the appeals judgment. Yeah.
Thank you very much, Ambassador.
Thank you very much.